Good to see. Hey, wait. And you don't send to us. Eh, tujue tumekuwa hapa. Mnatutumia. It's very short. I'm sure it's less than about. Oh, you just slide it.
That's good. I mean, they always, if they hear from this photograph, they'll go there and find out what is there. But they even or you want to say, yeah, it's easy, it's easy. Exactly like what you're on. My wife showed me a tweet last night. My wife showed me a tweet last night. It said, where is Ahmed Istighfar? I went out. I'll tell you the trick.
Very unusual for him. Kuna vita hapa anaanza kuhama. Very nice. Very nice. You know, I use it yes. Anyway, this particular thing is very good. I want to avoid the traffic. What will happen? Time to my own. Find then you can pass that. You pass it to that. So I want to read. Muhammad was asking secretary to walk out together. Muhammad goes back corridor now because they used to stand. So I was telling him, come and meet one of the foreign parties. What I meant wanakwenda hapo naenda kwa meza yake Mohamed anaona hii television ya juu yangu tayari ni yangu hivyo wanaingiza hapa hii wanaweka kando visa za faili ndio nini Mohamed yes. Activities. And the government is imposing the law of
Exactly the way you will face a long
contrary, I'm friends with my constitutional theories. No, actually, that's not what we were saying.
Oh, no.
Yes, 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 yes. Yes, 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 yes. Kabisa.
Good evening, ladies and gentlemen. We are very, very sorry that we are starting a bit late, but you will appreciate that we had 13 applications to deal with, and that is what has caused the delay. So we are very, very sorry that we are starting late. Before we start to read the applications, yesterday you remember I mentioned that we have visitors, prominent judges who are observing what the Kenyan Supreme Court proceedings in a presidential petition are. I would request, my lords, if it is not too much, if you could please come in front. Judge Zakala, please come. These are judges who are accompanied by Mr. Martin Masiga. I would request Mr. Masiga to introduce them. First of all, Mr. Masiga, say who you are, and then introduce the judges to us.
Martin Masiga, my name's. I am the Secretary General of the Africa Judges and Jurists Forum, which has organized this observation mission. With me, we have the head of the mission, the retired Chief Justice of Zambia, Justice Ernest Sakala, and is followed by Justice Hungwe Chinengo Moses from Zimbabwe, and is followed by Justice Bethwell Dingake from Botswana, and a senior legal advisor at the International Secretariat of the ICJ, Mr. Brian Penduka. And we are very pleased to be here. We are very honored, CJ.
Yes. Once again, we want to welcome you to Kenya and welcome you to these proceedings. You can now go back and sit down. Thank you very much. So as I said, the delay was because of the rulings that we writing, and I would now like us to start to read out the rulings, and I will start with Justice Lenaola.
Would you want us to state the quorum or we go straight to the ruling? Just seeking your guidance, Chief Justice.
Unless there is any difference.
Not material difference, I don't think.
Yes.
Okay.
And in any case, we have the written quorum here.
Yes.
Yeah. Thank you very much.
Thank you, my Lord Chief Justice. This is the application by Mr. Benjamin Barasa Wafula. Is he here? Mr. Barasa, you are seeking by your application to join this petition as an interested party. The court, in unanimity, has considered your application, and the court is of the view that your application lacks merit and it dismissed without any orders to costs. Thank you.
Thank you. Next, Justice Njoki.
This is the application of Mr. Michael Wainaina Mwaura, who seeks joinder in the capacity of intended respondent or amicus curiae. This court, having looked at the law which we have laid out and principles concerning an amicus brief, we find that the applicant does not meet the criteria set out in law to be amicus, and his application for that fails. However, having looked at the record, we find that the applicant meets the conditions set out in law on joinder to interested parties to a suit, having been a candidate in the just concluded general elections, and has shown a personal stake in the matter. We therefore state that the application is allowed, and we order that the applicant has written submissions to be filed by 8 in the morning by the 28th of August, that is tomorrow. Those submissions should be limited to 5 pages only, of not more than font 12 with 1.5 spacing. The next application is by the intended interested party, Ekuru Aukot. Again, as the court, we have looked at the law. We have found that Mr. Aukot, as a presidential candidate in the election of 8th August, has an identifiable stake in the matter, and he will be directly affected by the outcome of this petition. His application is therefore allowed. He is to file the alleged report in his affidavit by 8 a.m. tomorrow and serve upon all parties. He also must file his written submissions, again limited to 5 pages only, of not more than font 12 and 1.5 line spacing.
Thank you, my lady. We had, out of abundance of caution, already filed our submissions in the report, which is on record. So we wish that the same be adopted, because it's already served upon all the parties.
Very well, very well. That's okay.
Most obliged, my lord.
Yes. Thank you very much, my lords, my ladies, your lordship, the Chief Justice. The same position obtains in my case. I served my written submissions. I also served with the application an IT expert affidavit with annexures and the response to the petition by my client. I would, in the circumstances, then request that the same be deemed as filed and served for purposes of address in the main.
Very well, Mr. Kianjui.
Much obliged.
Thank you. Justice Wanjala.
Next is an application by the third respondent, which seeks to strike out or expunge from the court record documents which were not served by the petitioner upon counsel for the third respondent. The documents and annexures have been identified in the application, and the grounds upon which the application is made has also been highlighted. We have considered this application extensively, the affidavits in support thereof, and the submissions of counsel for both parties, and unanimously have arrived at the following conclusions, on the basis of which we shall make the final orders. That the application is solely based on the ground that the documents and annexures in question are filed and or served out of time, contrary to Rule 10, as read together with Rule 12 of the Supreme Court's Presidential Election Petition Rules. 2, the documents and annexures in question are not only in support of, but inextricably linked to the petition filed on 18th August 2017. 3, the documents and annexures in question had already been referred to in Dr. Nyangwasi's affidavit in support of the petition, which affidavit was filed and served in time together with the petition. 4, the documents and annexures in question were filed on 20th August 2017, long before the commencement of the following of the formal hearing of the petition. The application 5, the application herein, the applicant has not claimed nor demonstrated that the filing of the documents and annexures in question seek to introduce new evidence or change the character of the petition. And number 6, the retention of the documents and the annexures in question on the court record would, in our view, not jeopardize or seriously undermine the ability of this court to hear and determine the petition within the constitutional time limit of 14 days. We also note that the applicant has contended that failure to serve the said documents in time will seriously prejudice his ability to respond to the contents therein. This contention is not an idle one, and this court has always insisted that its rules must be followed for the orderly and expeditious conduct and disposal of disputes that come before it. However, in view of the findings and conclusions we have made, and in the interest of justice to all the parties in this petition, we are inclined to invoke our inherent jurisdiction in favor of retaining the documents and annexures in question on the court record. By the same token, in order to safeguard the applicant's rights to a fair hearing, we direct that the documents and annexures in question be served upon the applicant not later than 9 a.m. on Monday, the 28th August of 2017. The notice, therefore, of motion is hereby dismissed, and the costs shall abide the course. Next is an application by the first respondent seeking orders to expunge from the court record named documents in the application. We have also considered the application, the affidavits in support thereof, and submissions by counsel of both parties, and have noted that all the affidavits sought to be expunged from the court record application is based is that the same were filed out of time. We have considered the application, the affidavits in support, and submissions of counsel. The nature of this application is such that were it to be granted, it would dispose of the entire case of the first, second, and third respondents at this preliminary stage, and such a drastic consequence, in our view, cannot be justified if the scales of justice are weighed in favor of all the parties to this petition. For the same reasons, therefore, this particular application must suffer a similar fate, which is a dismissal, and costs shall also abide in the course.
Thank you. Just Wanjala, just Ujuang.
Mr. Al-Wachir, by his notice of motion of the 23rd of August 2017, supported by an affidavit of the same date, 6 joined her as an interested party in the instant matter. He urges that if he is denied joinder, he, as well as other Kenyan citizens, will suffer prejudice, as there is a real risk that the government, due to assume office, would stand in contravention of Articles 1, Sabbatical 1, 3, Sabbatical 2, 1, Sabbatical 2, Sabbatical 2, and 3, Sabbatical 1 of the Constitution. It is the applicant's case that the grounds of his application are different from those presented by the petitioners. He contends that while the grounds of the petitioner's case cover issues of the post-nomination day, voting day, and post-voting day, as well as vote counting records and vote tallying, his grounds are that the first and second respondents were not and are not eligible for election as president or deputy president in the terms of the provisions of Article 137, 1B, as read with Article 99, 1B, 148, 1, and Chapter 6 of the Constitution. The applicant contends that the third respondent is not a political party as defined in Article 91, 92, and 260 of the Constitution, and hence it did not have the legal capacity to nominate any person for elective office under the Constitution. Consequently, it is contended the election of the first and second respondents as president and deputy president is a nullity. The applicant contends that the third respondent has not been holding free and fair elections and has been acting unconstitutionally. The applicant seeks a number of reliefs, one of them being an order that the first and second respondents are not eligible for election as president and deputy president. Secondly, that for purposes of the general elections held on the 8th of August 2017, the third respondent had no legal capacity to nominate any person as a candidate pursuant to Articles 1999, 137, 180, and 193. In order to invalidate the election of the first and second respondents, and so on. Now, we have considered the law relating to this question. The applicable law on joinder of interested parties is embodied in Rule 4.2 of the Supreme Court Presidential Elections Petition Rules 2017, as read with Rule 25 of the Supreme Court Rules 2012. Rule 4.2, aforesaid, provides as follows, quote, where there is no applicable provision in the Act or in these rules, the procedure set out in the Supreme Court Rules 2012, insofar as they are not inconsistent with the Act or these rules, shall apply to an election petition, end of quote. And we have considered Rule 25 of the Supreme Court Rules 2012. Now, while the applicant seeks joinder in the suit as it is, his application introduces new parties and excludes some of the current parties. He seeks to be the petitioner, to have Uhuru Muigai Kenyatta as the first respondent, William Samoei Ruto as the second respondent, Jubilee Party as the third respondent, Wafula Chebukati as the fourth respondent, and the Independent Electoral Boundaries Commission as the fifth respondent. The applicant also wants us to delve into issues that featured in the 2013 presidential election. The applicant is, in essence, introducing new facts and issues that are not before us. This is a matter dealt with by this court in an earlier case, Trusted Society of Human Rights Alliance against Mumo Matemu and 5 others, Supreme Court Petition number 12 of 2013. We have given that passage. when the applicant introduces a new petition with issues not already laid before the court, he is improperly making claims on a cause that belongs to other parties in the main proceedings. This cannot be allowed. We are also not convinced that the applicant would suffer any prejudice if his proposed intervention is declined. We are inclined, in the circumstances, to dismiss the instant application. We make orders accordingly.
Thank you, Judge Ibrahim. Judge Ojwang, Judge Ibrahim.
Thank you, Mr. President. This is an application by Counsel Charles Kanjama, who is applying to be admitted as an amicus curiae. And in the notice of motion dated 25th August 2017, 6 joined to the petition as an amicus. There are various prayers, but the thrust of the application is to be joined as amicus of the presidential election petition hearing and to be represented by the firm of Muma and Kanjama advocates. He sets out the matters that he can bring forth for the assistance of this court, including burden and standard of proof, electoral irregularities, managing electoral timelines, context and application of information and communications technology, verification of tallying and transmission of results, interlocutory applications, scrutiny and recount in a limited frame, developing the role of amicus curiae, public interest. In the alternative, he seeks to be admitted as an interested party or intervener and allowed to participate in the proceedings. He has filed an affidavit in support of this application. He has set out the grounds on which the application is grounded, and they are all set out in the application, and which will give you an opportunity to read once you supplied copies. Now, after setting out at length the basis and the particulars, the respondents, the first and second respondents, oppose the application. And among other things, the first and second respondents first of all, the first petitioner, the petitioner opposes by way of a replying affidavit by Honorable Raila Odinga, dated 26th August. And it disabuses the applicant's alleged expertise in electoral process and avers that general practice in law does not suffice for admission of one as an amicus. Other reasons are also given. On their part, the first and second respondents also oppose the application, and they have deponed that the applicant has not demonstrated or established any field or expertise or knowledge that he would be submitting to aid this court in determining the petition before the court in this particular petition. The third respondent, in a replying affidavit deponed by Davis Kimutai Chirchir and written submissions, also oppose the application for joinder, and the reasons are set out at length. The determination of this court is that the jurisprudence as regards admission of amicus is settled and has been referred to in similar applications before this court in this matter. Before this court, in the application by the Law Society, while in this particular court, the Law Society has also sought to be admitted, as the record will show. While admission of an amicus is at the discretion of the court, we note that all parties in the petitions have opposed the admission of the applicant. Mr. Kanjama they have opposed the admission of Mr. Kanjama as an amicus, particularly that he does not possess the expertise he alleges to have, but he is of a general nature, and further, and with particular reference to the petitioners, that he seeks to introduce new issues not advanced by the parties herein. We have referred to the case of Supreme Court advisory opinion on the principle of gender, where Mr. Kanjama had been admitted as an amicus. But as we have said in this case, every case will be determined on its own facts and merits. On the contrary, in the petition before us, we are unconvinced that the applicant possesses sufficient expertise to address the court on the technological issues. The court holds that it does not require a person with a legal background as his primary professional discipline, which the applicant is, but a technocrat in information technology and systems, which is a secondary discipline possessed by the applicant. We reiterate that the fact that one was previously admitted as an amicus in a matter before the court is not sufficient ground for admission in a subsequent suit, as each case is determined on its own merit and unique issues and circumstances. The upshot is that the application for admission as amicus is hereby dismissed, and this is the ruling of the court.
Thank you, Justice Prime. The Deputy Chief Justice, please.
This is the ruling concerning the application by the Information Communication Technology Association, ICTA, applying to be joined into this petition as amicus curiae. We have looked at the brief. We have looked at the jurisprudence by the court on how one qualifies to be admitted as amicus. We have come to the conclusion that this applicant does not meet that criteria, and in the circumstances, his application is refused. We then have there shall be no orders as to cause on that one. We have the application by the Law Society of Kenya, who also applied to be joined as amicus curiae in this petition. We similarly have looked at their brief, the relevant law, the criteria, and we have come to this conclusion. At the core of this petition is the interpretation and application of Articles 81 and 86 of the Constitution. This places the matter squarely within the society's objectives. In this petition, it's also the question as regards the validity or otherwise of the people's exercise of their sovereign power. We find that nothing can be of great public interest so as to invite the safeguarding from the LSK than a question touching on the people's exercise of their sovereign power. Consequently, we find and hold that the LSK has made a case for its admission as amicus curiae in this matter. As the court reserves the right to direct the amicus on how to proceed, we direct that the LSK restricts its submissions on the single issue contained in its brief, particularly the rightful interpretation of Section 83 of the Elections Act in relation to of the Constitution 2010. The application is therefore allowed.
Thank you, DC Chair. I have before me the application made by the Honorable the Attorney General, also to be admitted in this petition as amicus curiae. The Attorney General wishes to assist the court on several issues, including what is the proper constitutional and legal standard applicable to the conduct of presidential elections in Kenya, as envisaged by Articles 81 and 86. What were the effects as regards the use of technology in the presidential election introduced by Elections Act Amendment Act number 36 of 2016 and the Elections Laws Amendment Act number 1 of 2017. What was the effect of the jurisprudence initiated by the Court of Appeal in the case of IEBC versus Maina Kiai? How should the Supreme Court treat rejected spoiled votes in determining the total votes cast under Article 138(4) of the Constitution? What is the proper constitutional and legal threshold for invalidating or upholding presidential election under Article 140 of the Constitution? And lastly, what remedies can the court grant in determining a presidential election petition under Article 140 of the Constitution? The application is opposed by the petitioners, having considered the amicus brief filed before us. We noticed that quite a number of issues that the Attorney General wishes to address us on are already covered by counsel who are appearing in this matter. So in the circumstances, we allow the Attorney General to appear as amicus curiae, but limit him only to one issue, the application, the issue of what was the effect of the jurisprudence initiated by the Court of Appeal in the case of IEBC versus Maina Kiai and others. So the Attorney General's application is allowed, but is limited to that issue only. Thank you. We have one application which we were unable to complete. We will deliver it first thing tomorrow morning at 9 o'clock. Immediately after delivering that ruling, that is the ruling by the petitioner on access, there are quite a number of issues that we would consider. So we will deliver it tomorrow morning at 9 o'clock before we start the hearing. Immediately after the delivery of that ruling, we shall commence the hearing. And this is how we will proceed. The petitioner shall have 5 hours. 5 hours, and considering the fact that you will have the right of rejoinder, you will have 5 hours. The first and the second respondents will have 1.5 hours each. The third respondent will have 3 hours, and the interested parties we have admitted, as well as the amicus curiae, will have 20 minutes each. And we are going to be very, very strict on time. So council, please organize yourselves. Those who are being assisted, if more than one council is appearing for a party, you will share the time allocated to you so that we are able to move. So with that,
can I make a small application with your leave? The documents, my Lord, admitted pursuant to the ruling delivered by my Lord Justice Smokin. Can we be given leave to reply to those documents latest by tomorrow? There are documents that have been admitted, so we need leave.
Very well. Yes, very well. What time tomorrow?
4.
Sorry?
Can we deliver it by 4 tomorrow?
For Mr. Abdinasil will be quite late.
Okay, by 1 then I think we will do it by 1.
The problem is that if it comes after we have submitted the 5 hours, then we'll not have any opportunity to comment if they're relevant.
So you're making, you know.
Yeah. So.
No, Mr.
Yes,
Nasir, please don't sit down before I allow you to.
Yes, my Lord. Yes.
They will need to respond to, in their submissions to whatever you will have stated, isn't it?
Yes, sir, but I think
you are many. Please ban the midnight oil. File the affidavit by 8:30 tomorrow.
My Lord, let's be very reasonable, my Lord. I don't think 8:30 is possible. Can we make it by midday? This is, to be fair, this is not our fault. It's their fault.
Yeah, but Mr.
These are documents that we have not been served even. I know that.
You don't.
Mr. Abdinasil, because we are starting at 9, and the counsel for the petitioner may wish to refer to that affidavit, let's be fair. I know you're being put under pressure, but we are all working under a lot of pressure. File it by 10:30 so that before they finish their submissions, they are able to.
I must oblige.
Yes.
I must oblige.
To proceed.
I talk on behalf of the first respondent. Those documents affect the first respondent as well. So we ask for the record that those orders be extended to us. We will file a response by 10:30 tomorrow.
Very well.
My Lord, without repeating what the other councils have said, on behalf of the second respondent, we would be requiring similar orders or directions on behalf of the second respondent.
That's fine. So I file them by that time.
Thank you.
Sorry to prolong the session, my Lord. The Law Society is grateful for being allowed to address you. May I seek direction on the order of address as between the amicus who have been admitted and the interested parties?
Yes.
So that when we are in court, we know exactly who follows who.
Yes. Thank you. Thank you very much, Mr. Mwenesi, for reminding me on that. The interested parties who supports the petitioner will submit immediately after the petitioner. The one who supports the respondents will also submit immediately after the respondents. The amicus, of course, don't support any party, so they will come last.
In that case, the Attorney General will have the first shot.
Yes, very well.
Much obliged.
Very well.
My Lord, just one issue. In specifying the time for the presentation and prosecution of the petition, you gave us 5 hours, which we are quite happy with. But you didn't specify the time for the rejoinder or reply.
1 hour. 1 hour for the rejoinder. Yes. Yes. That's it. That's it for tonight. Thank you very much.
That's fair. Now, so we've got 1.5 hours.
1.5 hours.